A Credit Repair Guide 2. Chapter 1. Fix errors on your credit report. Billing errors 1. The law defines a billing error as any charge for something you didn't buy or for a purchase made by someone not authorized to use your account that is not properly identified on your bill, or is for an amount different from the actual purchase price, or was entered on a date different from the purchase date, or for something that you did not accept on delivery or that was not delivered according to agreement. Billing errors also include errors in arithmetic, failure to show a payment or other credit to your account, failure to mail the bill to your current address if you told the creditor about an address change at least 20 days before the end of the billing period, or a questionable item or an item for which you need more information. If you think your bill is wrong or want more information about it, follow these steps. Notify the creditor in writing within 60 days after the first bill was mailed that showed the error. Be sure to write to the address the creditor lists for billing inquiries and to tell the creditor your name and account number, that you believe the bill contains an error and why you believe it is wrong, and the date and suspected amount of the error or the item you want explained. Pay all parts of the bill that are not in dispute, but while waiting for an answer, you do not have to pay the amount in question, the disputed amount, or any minimum payments or finance charges that apply to it. The creditor must acknowledge your letter within 30 days, unless the problem can be resolved within that time. Within 2 billing periods, but in no case longer than 90 days, either your account must be corrected or you must be told why the creditor believes the bill is correct. If the creditor made a mistake, you do not pay any finance charges on the disputed amount. Your account must be corrected and you must be sent an explanation of any amount you still owe. If no error is found, the creditor must send you an explanation of the reasons for that finding and promptly send a statement of what you owe, which may include any finance charges that have accumulated and any minimum payments you missed while you were questioning the bill. You then have the time usually given on your type of account to pay any balance, but not less than 10 days. If you still are not satisfied, you should notify the creditor in writing within the time allowed to pay your bill. A creditor may not threaten your credit rating while you are resolving a billing dispute. Once you have written about a possible error, a creditor must not give out information to other creditors or credit bureaus that would hurt your credit reputation, and, until your complaint is answered, the creditor also may not take any action to collect the disputed amount. After the creditor has explained the bill, if you do not pay in the time allowed, you may be reported as delinquent on the amount in dispute and the creditor may take action to collect. Even so, you can still disagree in writing. Then the creditor must report that you have challenged your bill and give you the name and address of each person who has received information about your account. When the matter is settled, the creditor must report the outcome to each person who has received information. Remember that you may also place your own side of the story in your credit record. Billing errors 2. After you have received your credit report, determine the status of your credit file. You should attempt to remove all unfavorable information using the methods outlined herein. Not all of your credit history is contained in either of the firm's files. Some information may be duplicated or not included in the other file. Your name and social security number are used for identification. Current and previous addresses, spouse's name, and date of birth are used for further identification. The credit information includes the merchant names, the subscriber number, credit account number, date opened, date closed, highest credit limit, highest amount of credit used, and repayment history. The last item is encoded into numbers, with a series of ones indicating perfect repayment. After you have received your personal reports, determine the status of your credit file. You should attempt to remove all unfavorable information using the methods outlined herein. When you receive your report, examine it very carefully. Make certain that all information is current and accurate. If you find any error, for example, a loan that you have paid off is still listed as outstanding, you can take immediate action to correct the error. You must write out exactly what the mistake is and explain the way that the information should be listed. Send photocopies along with all pertinent information to substantiate your claim. If you receive a computer printout of your credit file, there should be a space, usually on the right-hand side of the report, in which you may protest any item in your report that you feel is incorrect. After you have done this, make a photocopy, sending one copy back to the Bureau by certified mail. When the Credit Bureau receives your report and the information in question, they are required to investigate and advise you of the results of their investigation. There is no charge for this investigation. You have credit rights due to the Fair Credit Reporting Act passed in 1971. Anytime that you are denied credit, you now have the right to know why you were turned down. If, for instance, you are turned down for a charge account at a store, you will receive a statement from the store stating that you were denied credit and their reason for the denial. If their reason has anything to do with the fact that the store used a credit reporting agency, they must provide you with the name and address of the agency that supplied them with the report. If this should happen to you, you should make an appointment within 30 days to visit the credit agency so that you can review your report and find out what information in it is causing you to be denied credit. I suggest that you always visit the Credit Bureau. Men should always wear a tie and jacket and women should dress conservatively as well. It is very important to look professional and businesslike. It is also good to bring a friend along so that they can be witness whatever is said. Do not let the representative of the Credit Bureau confuse or upset you in any way. If there is anything that you do not understand, ask to have it explained again. If there is any information in that report that is not true or if you want to dispute any information on it, don't be afraid to do so. If the agency is wrong on any item on your credit report or file, demand a correction. By law, the company must investigate. Some bureaus will even make the correction on the spot to get rid of the hassle. If for some reason, you cannot prove that the item is in error or if you are having a disagreement with a certain creditor, you have the right to tell your side of the story in 100 words or less in a consumer statement. This will be added to your report. Often, creditors who see that you have taken the time and effort to dispute an item in your credit file will get rid of it. Many bureau representatives will even help you word your statement. Be sure to use this rule to your advantage. After making any corrections on your report, you have the right to demand that the Credit Bureau send corrected copies of your report to all creditors who have received the incorrect reports for the last 6 months. The credit bureaus will not do this automatically, only when asked, so make sure it gets done pronto. If, when looking over your report, you notice that it is missing a few positive items that you recall, you may want to invest some money to upgrade your report. Some credit bureaus will call creditors you name as favorable to you. If the information that you give turns out to be true, the item will be added to your report. There are small fees of $2 to $5 per item, but this small fee could be well worth it to you. Billing errors 3. When you receive your credit report, write down every piece of information that is inaccurate or untrue. Even if an entry is partially true, you may still want to dispute it. Especially if your credit report will be improved as a result. Read all of the instructions on the back of your credit report very carefully. Symbols may be used for much of the information entered and you will have to understand each one. It's easy to become confused, but a number you can call if you have a question will be provided. Write to the creditor or card issuer within 60 days after the first bill containing the disputed charge is mailed to you. Even if more than 60 days have passed since you were billed for the item, you still might be able to dispute the charge if you only recently found out about the problem. Send your letter to the address provided on the bill. Do not send the letter with your payment. In your letter, give your name and account number, the date and amount of the charge disputed, and a complete explanation of why you are disputing the charge. Be specific. To be sure your letter's received and so you will have a record, you might wish to send it by certified mail, with a return receipt requested. The creditor must acknowledge your letter within 30 days. Within 2 billing periods but no longer than 90 days, the creditor must have either resolved your dispute or give you an explanation as to why it's valid. If you're in the right, you pay no interest on the mistaken charge. If he's in the right, he must send you an updated bill immediately. If you're still not satisfied, you must notify him again in writing and proceed through other legal channels such as mediation and/or a lawsuit. A creditor is not allowed to give out information about your refusal to pay the credit bill while it is in dispute. Only after it is resolved and you haven't paid in the amount of time granted can he report you to the credit agencies for delinquent payment. While the bill is being disputed and investigated, you need not pay the amount in dispute. The creditor or card issuer may not take action to collect the disputed amount, including reporting the amount as delinquent, and may not close or restrict your account. If there was an error or you do not owe the amount, the creditor or card issuer must credit your account and remove any finance charges or late fees relating to the amount not owed. For any amount still owed, you have the right to an explanation and copies of documents proving you owe the money. If the bill is correct, you must be told in writing what you owe and why. You will owe the amount disputed, plus any finance charges. You may ask for copies of relevant documents. If the creditor made a mistake, you do not pay any finance charges on the disputed amount. Your account must be corrected and you must be sent an explanation of any amount you still owe. If no error is found, the creditor must send you an explanation of the reasons for that finding and promptly send a statement of what you owe, which may include any finance charges that have accumulated and any minimum payments you missed while you were questioning the bill. You then have the time usually given on your type of account to pay any balance, but not less than 10 days. If you still are not satisfied, you should notify the creditor in writing within the time allowed to pay your bill. A creditor may not threaten your credit rating while you are resolving a billing dispute. Once you have written about a possible error, a creditor must not give out information to other creditors or credit bureaus that would hurt your credit reputation. And, until your complaint is answered, the creditor also may not take any action to collect the disputed amount. After the creditor has explained the bill, if you do not pay in the time allowed, you may be reported as delinquent on the amount in dispute and the creditor may take action to collect. Even so, you can still disagree in writing. Then the creditor must report that you have challenged your bill and give you the name and address of each person who has received information about your account. When the matter's settled, the creditor must report the outcome to each person who has received information. Remember that you may also place your own side of the story in your credit record. You can dispute items on your credit report by contacting the reporting agency, giving them the information and insisting that they investigate. If they investigate and find that your claim is justified, they will change your report. If they investigate and find that your complaint is not justified, you can ask that a 100-word consumer statement be included with your report to explain why you think it's wrong, and you can also go to the original party that the bill came from and try to settle it with them. Make sure you get this same information changed with all the other credit reporting agencies. Here are steps you can take to have damaging entries removed from your credit report. 1. Make a list of inaccurate or untrue entries that you find in your credit report. 2. Call the credit bureau and tell the appropriate person that you want to dispute an entry you have noted on your credit report. 3. Don't allow any credit bureau employee to talk you out of proceeding with your appeal. To avoid a distracting confrontation, don't even tell them you want to challenge. They won't initiate any action on your behalf anyway until they receive your appeal request in writing. 4. To initiate the proper appeal procedure, ask the person you speak with to send you a dispute form. 5. Complete the dispute form and return it to the credit bureau by certified mail. 6. When the credit bureau receives your written dispute request, they will then attempt to verify the dispute you have indicated with the bank, lender, or creditor responsible for having the damaging information listed. 7. You will be notified of their decision within 30 to 45 days. When a computer billing error occurs, pay the undisputed amount only and notify the company immediately about the disputed item. Dispute resolution programs in consumer beefs may be quicker and cheaper than going to court. Either your Consumer Protection Agency, Better Business Bureau, State Attorney General, or Small Claims Office can recommend some mediation resolution programs to you. If you file suit and win, you can recover damages for any actual financial injury which you sustained as a result of the violation. Twice the amount of any finance charges involved. Court costs and attorney's fees. If you purchase goods using a major credit card and they turn out to be defective, you can withhold payment if the following conditions are met. The purchase price was more than $50. The purchase was made in your state or within 100 miles of your mailing address. You made an honest effort to clear up the problem with the store first. This right may be limited if the card was a bank or travel and entertainment card or any card not issued by the store where you made your purchase. It's a good idea to send a letter to the credit card company telling them about the situation. The credit card company may not accept your claim that the goods are defective, in which case they could sue you, but if the goods are defective, you can defend against it successfully. Scam artists can set up shop in Canada or in the Caribbean, and once they have your credit card or check number, they can debit your account fraudulently, but you have to be vigilant in order not to take the loss. Federal Trade Commission. Public reference. Washington, D.C. 20580. 202-0326-2222. FTC.gov. Will process your complaints against unscrupulous loan companies who don't disclose all facets of a bill. Free booklet, Road to Resolution, Settling Consumer Disputes. International Center for Dispute Resolution. ICDR.org. Billing errors 4. Very briefly, we'll go through the steps one more time. Request your credit report. Review it. Pick out the errors, state your case as to why they're wrong. Send a letter disputing credit. Keep a record of letters you sent and letters they sent to you. Wait 30 days. If they have not responded, send your second request for re-investigation. Wait either 30 days or 45 days if you provide additional information. If there is no response, contact the FTC and tell them you received no response, which is a violation of the credit laws. Once the FTC intervenes and the error has been corrected, request a new copy of your credit report to make sure this has been done. If the credit agency doesn't believe your case, it will not remove the item from your credit record. If you still want to fight, contact the customer service department of the creditor directly, as opposed to the CRA. Dispute the item with them. Remember, you can wear them down. If they don't respond by the legal time limit, the item goes off. Billing errors 5. In order to fix up a bad credit report, first apply for a credit card. When you receive the rejection letter, it will list the name, address, and phone number of the CRA they used who said you were a bad risk. Send this CRA a letter requesting a copy of your credit report. By law, you're entitled to get one credit report free when you're rejected for credit, otherwise it costs about $10 to $20 per credit report. When you get your credit report in the mail or by fax or email, identify your trouble spots, then simply write a letter back disputing each of them for one reason or another. The reason doesn't matter even if you have to lie about it. The intent is to get the legal procedure going. When you challenge a charge, the CRA has to contact the creditor and give him or her 60 to 90 days to respond, to either deny your charge, agree with it, or not respond at all, in which case the item goes off your record. If you send in your dispute before summertime or before Christmas, oftentimes, they won't get to the paperwork within 90 days, in which case the item automatically goes off your credit record. Sometimes, if the bill is older than 3 years old and is for an amount under $1,000, they'll just ignore the CRA's letter, in which case after 90 days, the item will go off your record. If they dispute your charge that the bill is wrong, that's fine. You just play a waiting and attrition game with them. Wait a month or two, send another letter to the CRA challenging the bill again. Keep doing this until the creditor either slips up or gets tired of the whole thing and doesn't respond, whereby the item goes off your credit card. Bankruptcies stay on your CR for 10 years. According to federal law, everything else automatically comes off after 7 years, no matter how bad your credit was, so theoretically you can rip off the system until your credit is trashed, then after 7 years, it's all off your record and you can start building up a new credit profile again. If you have a bad debt that the creditors won't remove, according to federal law, you can attach A written statement of 100 words or so to your credit file to explain it. Either tell the truth and say you're a good bill payer except for that one time, or lie and blame it on poor record keeping on the part of the creditor. Build a good credit history applying for the easiest types of credit cards to get: gas and department store cards. Try to get a loan at a bank even if you have to start up a savings account with the amount of the loan in it as collateral. When you make regular payments on the loan, it will go on your CR and you will build up a good credit history. Overall, lenders give higher marks on a credit score for the following conditions: own rather than rent a home. Have been at their current jobs for at least 2 years. Work for someone else rather than being self-employed. Lived at present address for several years. The higher the salary the better. After you get your first credit card, buy a few things every month, then pay it off in full every month for several months. This will help build up your CR. Once you get a good CR, you'll be able to get major credit cards like Visa and MasterCard as well as the American Express Bank card. Before you get a credit card, find one that doesn't charge an annual fee and has reasonable interest rates.